Last week, I mentioned that the Supreme Court was still sitting on Donald Trump's tax returns. There were a number of lawsuits involving the Orange Bastard that were presented to the Supreme Court while the Orange Bastard was president. And for nearly 4 months now, the Supreme Court has refused to act on emergency filings related to a Manhattan grand jury subpoena of the Orange Bastard's tax returns, which was stopping the investigation. Well, surprise, surprise, today, Monday, the Supreme Court rejected that last-ditch effort by the Orange Bastard to shield his fraudulent tax records that are going to get his ass in jail. The Supreme Court issued a brief unsigned order requiring Trump's tax accountants, that's Mazars USA, to turn over his tax records and other records to prosecutors in New York. Aha. An order requiring the Orange Bastard to turn it over. Now, as the Times reports it, this order from the Supreme Court is a big-ass defeat for Trump. The Orange Bastard, as you know, had gone to extraordinary lengths to keep his tax returns and all sorts of documents that are going to put him in jail a secret. And in the order from the Supreme Court, there was no dissent noted. Not even Uncle Clarence. Not even Amy Catholic Barrett, not even Sammy the Fish. Nobody dissented. It was an unsigned order. It just said, turn the fucking things over. Well, probably not the F word. Now, the case concerned a subpoena to Trump's accountants, Mazars, by Cyrus Vance's office. He's the Manhattan District Attorney. Anyway, Mazars USA, the accounting firm, had said it would comply with the final ruling of the courts whenever that was presented. Well, it came down today, boys. That means that the grand jury investigating this slimy, filthy Trump should get these documents in very short order. Cyrus Vance issued a 3-word statement today in response to the court's order. Here's what Cyrus Vance said, quote, "The work continues." End quote. Woohoo. Now, under grand jury secrecy rules, of course, star chamber rule shit, it would ordinarily be unclear when, if ever, the public would see the information. But the good old New York Times has obtained more than 20 years of tax return data of Trump and his companies. And the Times recently published a whole series of articles, several weeks ago, about those documents. And the article said that Trump has sustained significant losses, owes enormous debts that he's personally obligated to pay, has avoided paying federal income taxes in 11 of the last 18 years, and paid just $750 in both 2016 and 2017. Oh, I'm sure it was all legal, right? I mean, after all, he is Jesus H. Christ's cousin, right? Ask any Christian evangelical, the white ones. Now, the scope of Cyrus Vance's inquiry obviously is not known. It's known only to the staff of the Manhattan District Attorney's Office. But it came partly from an investigation by Vance's office into hush money payments to 2 hookers who said they had affairs with Trump. Well, I don't know if they're hookers. I guess I shouldn't say that. But 2 women. I just assumed that anyone who would have sex with this Orange Bastard would have to be doing it for money. Consequently, the use of that term. Now, of course, Trump denied all this, but the court filings by prosecutors suggested that they're also investigating potential crimes like tax and insurance fraud, not just hush money payments that would be misuse of campaign finance funds. Oh, what, I have to pay some other broad to keep her mouth shut? Take it out of the campaign money, right? You do it there, Michael Cohen. God, this slummy, scummy bastard. Anyway, the subpoena that has been languishing until this morning in the Supreme Court sought Trump's tax records and financial statements over the past 10 years, since 2011. And the agreements with the accountants who prepared those tax records, what they're called engagement agreements, how far they're going to go with this, that, or the other thing, what the client, in this case the orange bastard, what he expects and is allowing or disallowing from the tax accountants, and additionally the underlying raw financial data and information about how the data were analyzed. So we want to know what Cyrus Vance is saying. Because I'm investigating potential crimes here committed by the orange bastard, Cyrus Vance wants to know what data were used to construct these tax returns and where the input that produced the data came from and how the data were analyzed. What did this mean? What did that mean? Oh, Jesus God. Anyway, if you remember back when the orange bastard was a candidate and he promised to disclose his tax returns, but they're under audit. And of course, he never did. Instead, what he did do was fight like a mofo to shield the returns from any kind of scrutiny. Why? Well, who knows? But I think we're about to find out, relatively speaking. And back in 2019, the U.S. Court of Appeals for the Second Circuit in New York ruled that state prosecutors in New York can require third parties to turn over sitting presidents' financial records if they're to be used in a grand jury investigation. But it took the past 2 years to get the Supreme Court to rule, the Second Court of Appeal, the Court of Appeals of the Second Circuit was right in what they ruled. So, Mazars USA, turn the goddamn things over. Yuck, yuck, yuck. Anyway, so after that ruling by the Court of Appeals for the Second Circuit in New York, Trump appealed to the Supreme Court. And then in July, the Supreme Court justices totally rejected Trump's central constitutional argument against the subpoena, and that was that state prosecutors are powerless to investigate a sitting president. And if you remember, that was when Chief Justice John Roberts wrote for the majority in that decision against Trump, quote, "No citizen, not even the president, is categorically above the common duty to produce evidence when called upon in a criminal proceeding," end quote. Now, even though Uncle Clarence and Sammy the Fish, the two ultra-conservative Gonoffs on the Supreme Court, dissented from other aspects of the decision, all 9 justices agreed with that proposition that no citizen is categorically above the common duty to produce evidence when called upon in a criminal proceeding. I mean, even Uncle Clarence and Sammy the Fish had to agree with that one. So, even when they ruled, though, the Supreme Court gave Trump another opportunity to challenge the subpoena on narrower grounds. Now, this is back in July, and that's when Chief Justice Roberts wrote, quote, "A president may avail himself of the same protections available to every other citizen. These include the right to challenge the subpoena on any grounds permitted by state law, which usually include a subpoena issued in bad faith, an undue burden, or the breadth of the subpoena." Was the subpoena, in other words, so broad that it required Trump to turn over all sorts of documents that might not be pertaining to his paying off of women for their silence after he had sex with them. So Trump did just that, what Roberts wrote. But his arguments were rejected by a trial judge and a unanimous 3-judge panel of federal appeals court in New York. And then it went to the Supreme Court, which was what was ruled on today. The panel said, the 3-judge panel of the Federal Appeals Court in New York said, quote, any documents produced under the Mazars subpoena, that was his accounting firm, would be protected from public disclosure by grand jury secrecy rules, which greatly reduces the plausibility of the allegation that the district attorney is acting out of a desire to embarrass the president. That was part of Trump's defense for not wanting to turn these documents over to begin with. And then the 3-judge panel added this, quote, there is nothing to suggest that these are anything but run-of-the-mill documents typically relevant to a grand jury investigation into possible financial or corporate misconduct, end quote. So after that 3-judge panel ruled that, Trump's toy lawyers then filed an emergency application asking the Supreme Court to intercede. And the Orange Bastard's lawyers urged the court to block the appeal court's ruling while the Supreme Court decided whether to hear another appeal from Mr. Trump. You see, if you have enough money or credit or something, or you're president, you can keep this shit going forever. But forever has ended for the Orange Bastard. Now, the brief filed by Trump's toy lawyers said this, quote, even if the disclosure of his papers is limited to prosecutors and grand jurors, the status quo can never be restored once confidentiality is destroyed. Oh, really? It went on. But the harm will be more than irreparable if the records are publicly disclosed. It will be case mooting, the strongest possible basis for a stay. Now, I don't know the term case mooting. I guess it means it makes the case for secrecy moot. In other words, useless, worthless, invisible, doesn't exist. Everything that the Orange Bastard has tried to do in using the courts since the son of a bitch has been president has been his attempt to stymie the courts, to interfere with justice, with the application of the law as it's written to him. Everybody else can go screw. They can go to prison. They can be executed. Remember how Trump ordered his Justice Department to speed up the executions of people being held on federal charges of the death penalty. But when it comes to Trump, slow everything down. Slow it way down. You know, I hope it doesn't take my own death for me to never hear the name Trump again. Sometimes I worry that is the case, that he has become just so permanently embedded in criminal activity and unconstitutional activity and terrorism in the United States and all things vile and filthy and rotten and illegal, that he's almost become part of the language, the everyday language, this ugly bastard. They talk about him from pulpits in these sick Christian fascist churches. They talk about him in QAnon and the Proud Pricks and all these terrorist organizations that are wandering around the United States insisting they're here to defend democracy, when in fact what they're here for is to destroy everything. I just wish that he would disappear, if you know what I mean. I'm so sick of hearing his rotten name. Oh, my God. Hi, Truth Seekers. Mike Malloy here. As you know, we've switched formats and are now broadcast exclusively on the Progressive Voices Network. So that means you get fewer program interruptions, no corporate commercials, and lots of profanity. But our format change also means some of our radio listeners no longer hear the program. It's been a while since I mentioned our podcasts, so you may have forgotten that there is a way to listen to this program anytime you need a good dose of screaming. Visit MikeMalloy.com and subscribe to our podcasts. As a podcast subscriber, you can download the program to your mobile device and take me with you wherever you go. And if you have a friend who needs a dose of truth-seeking, you can give a gift subscription as well. That's MikeMalloy.com, and never miss a minute of the uncensored fun and frivolity.